Today, we will discuss the many downsides of dissolving a business as opposed to the legal process of redomestication when attempting to move an existing company from one state to a new state. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at the university level and hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. Dissolving a corporation or limited liability company and quote unquote starting fresh may seem like a clean slate to the layperson, but it is almost always the most expensive, dangerous, and legally reckless approach that a business owner can take when changing the state of domicile for an existing business entity. Not only does it trigger a cascade of federal and state tax consequences, but it also forfeits years of business history, destroys contractual continuity, and eliminates your legal right to limited liability. Business owners who take this reckless approach routinely find themselves scrambling to reestablish credit, reapply for licenses, and explain to vendors, clients, and lenders why their once established business has seemingly vanished. Your federal employer identification number is tied to your existing business entity. Dissolving the entity causes that EIN to terminate for both legal and tax purposes. This forces you to apply for a new EIN, which signals to the Federal Internal Revenue Service and financial institutions that you are starting a completely new business. You cannot carry over payroll tax accounts, business credit lines, vendor relationships, contracts, trusts, or trust established with clients. The business you built, its name recognition, payment processing history, and good standing with state and federal agencies disappears overnight. By contrast, redomestication preserves your federal employer identification number and contracts, keeping your tax records, banking relationships, and operating infrastructure fully intact. When you dissolve a business and create a new one, you are not merely changing the name and state on paper. Even if you keep the same name, you are legally terminating the original party to every existing agreement and contract. Let's put that in perspective for a moment. Your commercial lease, independent contractor agreements, vendor purchase orders, and customer service contracts all go down the drain. Worse, any continuity clauses, non-competes, or asset protections tied to your old entity may no longer be enforceable. In many cases, courts may treat you as having abandoned contractual rights. This means your new entity will not be protected by the terms negotiated under the old one. In some jurisdictions, courts may pierce the veil entirely, treating the new entity as a sham, thereby potentially exposing you to personal liability. Filing articles of dissolution does not by itself close your business tax accounts. It merely creates a conflict between state legal records and IRS filings. Unless every federal and state agency is properly notified and closure is handled with care, you may continue to accrue tax penalties, fees, and interest on the entity that no longer exists in the state records. The IRS may treat the dissolution as a taxable event, particularly if assets are distributed to owners or quote unquote transferred to a new business without the appropriate documentation. Many business owners unknowingly trigger gain recognition or constructive dividend treatment, resulting in sometimes significant tax liabilities. Redomestication avoids all of this complexity by continuing the existence of the original legal entity under a new jurisdiction, thereby preserving tax and legal continuity. Lenders, insurers, and professional licensing authorities do not look kindly on entities that disappear and reappear under different names and in different jurisdictions. It certainly looks shady, to say the least. Even if the owner is the same, a newly formed entity is treated as exactly that, a new business, often requiring new applications, new security deposits, new personal guarantees, and potentially multi-year waiting periods for approvals in some cases. A dissolved company loses its Dun and Bradstreet number, credit history, and most importantly, its established reputation. For example, if you reapply for a contractor's license, you may be required to retest or requalify. If your business had any key permits, contracts, licenses, or bonds in place, they will not automatically carry over. With redomestication, on the other hand, you retain that all important continuity, thereby preserving all prior approvals and minimizing bureaucratic delays in many cases. Business owners who attempt a DIY dissolution and restart often find themselves paying lawyers and CPAs, like me, 5 to 10 times the original cost just to repair the aftermath. These attorneys must draft new contracts, notify all stakeholders, address missed tax forms, and reestablish contractual relationships. Some damage cannot be undone. Clients who discover a dissolved business may question your credibility. Contracts terminated by operation of law may not be restorable, or at least not on the same terms. You may lose legacy insurance policies, historic coverage dates, or ongoing litigation defense rights. In contrast, redomestication is a surgical, precise transfer that keeps your entity's legal existence alive while merely relocating it to a new jurisdiction. That means no new bank accounts, no reissued stock or ownership interests, just a change in domicile done the correct way. A limited liability company or corporation that is not properly registered to operate in a new jurisdiction risks being deemed a non-entity for legal purposes, and it carries with it substantial fines and penalties in many cases. If you dissolve your prior entity and fail to establish the new one correctly, courts can and will ignore the corporate form. This means that any debts, judgments, or lawsuits against the so-called new business can reach your personal bank accounts, home, or other assets. Even worse, Florida law imposes strict penalties, as does Texas, for operating without authority, including fines and, in some cases, criminal prosecution. By contrast, redomestication preserves the legal identity of the business, including its liability shield, ensuring the company, not you, remains responsible for its obligations, thereby potentially keeping you out of bankruptcy court. For many industries, particularly healthcare, construction, and professional services, a change in federal employer identification number or legal entity status requires regulatory disclosure and relicensing. This can delay business operations for weeks or months, and in rare cases, even years. The Federal Internal Revenue Service, meanwhile, will continue to expect tax returns for the entity until that entity is formally dissolved and the appropriate documentation is filed with the IRS. If you fail to submit the correct forms, such as IRS Form 966, the final employment tax returns, and updated 8822B notices, the government may initiate an audit or assess penalties. These are not hypothetical risks. They happen every month to unsuspecting business owners who thought handling the matter themselves because they, quote unquote, knew the law, or they simply wanted a restart, would solve their problems. Redomestication avoids this chaos entirely by keeping the legal entity intact while changing its state of domicile. By redomesticating your company, you will retain your federal employer identification number, contracts, licenses, credit history, litigation rights, and entity status. You do not need to notify creditors, vendors, clients, or banks of a new legal entity. You do not need to rewrite agreements or change your brand. Your business continues uninterrupted legally, financially, and operationally. There is no tax recognition event in most cases when this process is handled by a competent, experienced attorney. There is generally no need to reapply for professional licensure. In most cases, you can continue to utilize your existing legal name and branding with no disruption. The only thing that changes is your state of domicile. In conclusion, do not burn your business to the ground just to cross state lines. Dissolving your corporation or LLC and starting over is not a clean break. It is a scorched earth tactic that will cost you far more and will take far longer than hiring an experienced attorney to redomesticate your company properly. You will lose your business identity, your contractual protections, and your customer goodwill. The better option, that is to say, the professional, legally sound option, is to redomesticate your business with the help of a licensed attorney and a CPA. Preserve everything you have built. Avoid a legal and tax disaster. Make the move to your new state the right way. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.